Charles Peckham here on a hot-button issue in employment law. Neither federal law nor the Texas Labor Code prohibits discrimination based upon gender identification or gender preference. Some courts have come close, however, to interpreting the law to protect them. This issue is before the 11th Circuit now, following on a watershed case in the 5th Circuit, the federal circuit that oversees our own Texas. The U.S. Supreme Court has ruled that same-sex sexual harassment is actionable. That came from the 1998 case of On Call v. Sundown. Since that time, there's been a question about whether the discrimination and harassment that took the form of accusations of homosexuality could be considered sexual harassment, or the now non-prohibited gender preference discrimination. In the 2012 case of Bow Brothers from the 5th Circuit, we have an answer that will likely last until the Congress expands the law to protect workers in the LGBTQ community. Although the Bow Brothers Court did not rule on this issue, it did say that the use of epithets of the type commonly made toward homosexuals and the simulation of homosexual sex acts would have suggested that the actions were based on sexual orientation that's not actionable. However, use of words suggesting the male worker was effeminate or other physical or emotional characteristics would have indicated actionable gender stereotyping, which the court said is indeed actionable as gender discrimination. To be actionable, harassment must be unwelcome and viewed objectively so severe or pervasive as to alter the condition of one's employment. Courts say that Title VII is not a general workplace civility code and that simple teasing, offhand comments, sporadic use of offensive language, and occasional gender-related jokes won't support the Title VII claim. However, discriminatory intimidation, ridicule, or other verbal or physical conduct may be sufficiently extreme to do so. In Bow Brothers, because the nature of the abuse was related to gender stereotyping, because the employee often complained of it, and because it occurred several times a day, also for several months, the court upheld the jury verdict that it was unwelcome, severe, and pervasive. So, Bow Brothers opened the gates to gender stereotyping, now that's gender stereotyping cases, in the 5th Circuit. There are some other takeaways. Here, the company had a boilerplate anti-discrimination policy, but it didn't cover harassment, illustrate what conduct was impermissible, or make it clear that conduct need not be motivated by sexual desire to be illegal. Therefore, if a company does not have a properly instructive policy and does not train their employees to that policy, they cannot as easily fall back on the policy to say, we've protected our employees from discrimination. Also in Bow Brothers, there was a clearly insufficient 20-minute investigation after the complaint. Bow Brothers tells us that a short and improperly handled investigation may not protect an employer from liability, as it isn't really designed to protect the employees. So, we know, first, employers must seek to eradicate harassment or any form of discrimination involving gender stereotyping, sex or gender discrimination, and it doesn't have to be based on a prurient interest or sexual desire. Second, employers must have comprehensive, well-thought-out anti-discrimination and anti-harassment policies that define and provide examples of illegal conduct, are communicated to employees, and they're taught to employees. They clarify how complaints are to be filed and contain a sound resolution procedure. Then they must do more than post these policies on a wall and give lip service to enforcing them. Bow Brothers Court stated that the company might have prevailed if it had done more in this area. Third, employers must realize that courts are becoming less likely to listen to the excuse that employees were just engaged in horseplay. Fourth and last, employers cannot afford to give short shrift to an allegation of gender stereotyping because they don't want to have to deal with it, or it sounds unrealistic, or the victim appears capable of handling it by him or herself. Instead, employers must carefully and objectively investigate all complaints. Employers must also not punish the complaining employee, which unfortunately happens in far too many cases. I hope this update has been helpful.